There are situations where the employer-employee relationship proves unfairly detrimental to employees. Connecticut lawmakers implemented the Connecticut Fair Employment Practices Act, which acts to legally prohibit an abusive exploitation of Connecticut's standard modes of employment. Any employer who refuses to hire or terminates an employee due to an individual's race, color, religious creed, age, sex, marital status, national origin, ancestry, present or past history of mental disability, learning disability, or physical disability, including but not limited to blindness. This prohibition applies to all employers, employment agencies, and labor unions. It further prohibits employees in the aiding or coercion of any such act. The act further prohibits the discrimination of women based on sex, pregnancy, or their familial obligations. This covers a woman's home life, family, medical choices, as well as other relationships so long as they are not proven to interfere with a bona fide occupational qualification. Should any of these conditions be proven, an employer will be liable for wrongful termination regardless of an original at-will employment agreement. While the Connecticut Fair Employment Practices Act is extensive in its protection of employees from discrimination, there are some applicable exceptions that employees may want to be aware of. The statute is not intended to protect individuals from mandated retirement, and specifically excludes individuals over the age of 65 from its intended scope. In addition, the Act is not applicable to businesses that employ less than 3 employees. And quote, because Fair Employment Practices Act clearly expresses a public policy determination by legislature that employers with fewer than 3 employees shall be exempt from liability for discrimination on the basis of sex, including pregnancy-related discrimination, a common law claim for wrongful discharge on the basis of pregnancy will not lie against such small employers. If you feel you have been mistreated by your employer or in your place of employment and would like to explore your employment law options, contact the experienced employment law attorneys today at 203-221-3100 or by email at jmaya@mayalaw.com. We have the experience and knowledge you need at this critical juncture. We serve clients in both New York and Connecticut, including the New Canaan, Bridgeport, White Plains, and Darien areas.